anything on it.
For the reasons contained in a judgment prepared by Lord Walker, the Board will humbly advise Her Majesty that this appeal should be dismissed. The parties have 21 days to make written submissions as to costs.
My Lord, there is just one matter I'd like to raise at this stage in relation to costs, and I'll be extremely brief. It has been raised in correspondence between solicitors, and that's that the first appellant is an unincorporated association, the second is an individual. There's no grounds to think that either has substantial means, and we would respectfully ask for an order that in those written submissions the appellant discloses the identity of its funder.
What's your position on that?
My Lords, I'm afraid I can't comment on whether there has been correspondence between the solicitors on this matter, but I haven't had notice of it until 5 minutes ago, so perhaps inevitably I don't have detailed instructions from my clients in the Bahamas, and in those circumstances I would simply resist the application.
Yes, well, I think you'll obviously raise this point in any submissions which you put in about costs, and the matter will be dealt with in the context of that.
Then I simply ask for my Lords to make a note of that, if that's possible.
Well, I think you can take it to the wheel. Thank you.
Appeal for hearing Mossell Jamaica Limited versus Office of Utilities Regulation and
Yes, Mr. Fleming. Take your time if you want to get your papers organised.
Get my tackle in order.
Yes.
My Lords, in this appeal, I appear for the appellant. If I could summarise their name, reduce it to the word Digicel, and I appeal with my learned friend, Mr. Paul Bezic. The first respondent, the Office of Utilities Regulation, referred to either as the OUR or the Office, is represented by my learned friend, Mr. Batts, Mr. Braham, and Miss Risden Foster, who are on my left.
Mr. George Wilson.
And Mr. George Wilson.
George Wilson.
I do apologise. And also Mr. George Wilson, who I was introduced to a moment ago and forgot to mention his name. The second respondent, Cable and Wireless Jamaica Limited, referred to either as Cable and Wireless or CW, is represented by my learned friends Miss Minot Phillips, Mr. Garcia and Mr. Goff. The third respondent to the appeal does not appear. My Lords, there were 4 agreed issues in the statement of facts and issues, together with an additional issue raised by Cable and Wireless, to which Digicel has objected, and some supplementary issues already covered by and wrapped into issues 1 and 3. Lord, I hope the committee has been informed that after long and anxious consideration, Digicel has decided not to pursue issue 4, the rationality challenge, which is predicated on the ministerial direction being invalid, and we have decided not to trouble your lordships with that issue. However, it still remains necessary, subject of course to judicial tolerance, to examine in some detail the statutory framework to identify and consider the powers and duties of the OUR and also of the Minister. However, I'm hopeful that the removal of issue 4, which would have involved a fairly extensive examination of the factual history, will reduce these submissions considerably. My Lords, I'm not sure whether you have been provided this morning, as I just have, with a helpful glossary of terms provided by the second respondent. I was handed a few minutes ago.
I don't think we have, but it will be very welcome.
I thought it might. In fact, there's already, it's a 2-page document. I commend it to your lordships with one caveat, and the caveat that may become of some importance. It's as far as we can see on a quick run-through, it's a helpful, indeed a very helpful summary of the various acronyms and terms that bedevil this area of law, indeed of operations, but it is not, as long as it's treated as not jurisdiction specific, it is helpful. It doesn't address the peculiar regime that applies in Jamaica and indeed elsewhere, the calling party pays regime, to which I'll have to turn. But subject to that, my Lord, it's helpful. And your lordships may also have found in the bundle, but we haven't pointed you to it, in bundle 5, just before we get to the decision of the Court of Appeal, should be tab 50, is a document headed Respondents Technical Primer. The respondent then was Digicel, so it was prepared from the Digicel camp, but it's also similar to what you've now been shown, but perhaps also helpful in diagrammatic form in explaining the elements of a phone call and how we then get to decisions or determinations 2.6 and 2.8. Or at a convenient time, I'll deal with that document. My Lord, in light of the treatment of the argument by the Court of Appeal, and indeed the detailed submissions made by the OUR and Cable and Wireless, my Lord, we thought it helpful if we could spend some of our time taking your lordships through that statutory framework that I've mentioned in a little detail, but using it also as a jumping off point to deal with various related matters. That again should shorten the oral submissions on the remaining issues. My Lord, just first of all, a background piece of history. You will all no doubt have been aware, having picked this up from the cases and the judgment, that until the reforms in 2000, the incumbent telecommunications supplier, Cable and Wireless, had a monopoly and had been in that position for some 50 years or so, the duration really of telecommunications, and it had a license extending into 2012 or 2013. And that is very important, indeed central background material, because in the late 1990s, the government of Jamaica decided to introduce competition and bring that monopoly to an end. And there was to be a phased introduction of competition over the period effectively from 2000 to 2003. The minister responsible for and committed to the liberalisation of the telecommunications sector was Minister Paulwell, who is the same minister who made the direction, which is the subject of issues 1 and 3. And he put evidence before the court, the first instance court and the Court of Appeal, which was uncontradicted. And he explained in the first few paragraphs of his affidavit how this move towards liberalisation was brought about. And, my Lord, if I could show you that very briefly, it's only 4 or 5 paragraphs. It's volume 3, my Lords. His affidavit, which I shall return to later, is at tab 17, if you, I hope, have tabs, beginning at the record page 1236. And your Lordship will see his role in paragraph 1, and you'll see also that he is responding, which becomes important when we look at the evidence and the decision of the Court of Appeal. He's responding to the affidavits for the OUR from Mr. Hay and Mr. Jackson. But in paragraphs 3 to 7, he sets out in short form the history of his own career and how he was central to the introduction of liberalisation. In paragraph 3 and 4, you'll see in particular in paragraph 3, in the third sentence, that he was the executive director of the Fair Trading Commission during the period 1993-1995, so peculiarly experienced in the fair trade world. The duties and responsibilities relating to each position held by me during this period involve competition issues, and in particular the liberalisation of particular sectors of the economy. It has always been my fundamental belief, and one which has strengthened over the years, that the promotion of fair and open competition within the various sectors of the economy, balanced with the appropriate regulatory mechanisms, is one of the best means to ensure growth in the economy and maximise benefits of the consumer. Then at paragraph 5, you will see that not only was he involved in competition in the telecommunications sector, that's paragraph, the first sentence, but he was involved in the drafting of the policy and legislation relating to the Fair Competition Act and its passage through Parliament. And 6, when I assumed the duties of Minister with responsibility for telecommunications, I committed myself to the liberalisation of that sector, and hence was instrumental in the development of a telecommunications policy framework, which was completed in 1998, and the object was to move telecommunications from a monopoly-based industry to one that thrives on competition consistent with global trends. And then there's a reference to interconnection. It will be required to ensure access to the incumbent PTC's public telephone structure in a fair and non-discriminatory manner with recourse to the regulator in the case of dispute. He there exhibits, my Lord, and I won't trouble you with the detail, the policy framework, which was dated October 1998. It's part of the record at page 1244, and your Lordships will see by just a cursory reading of it that competition is central. Indeed, the regulator, as you'll see on page 1256, is mandated, or will be mandated, to facilitate effective competition, except where this would infringe the licenses of the incumbent. And in paragraph 7, then I'll leave this document. I commenced negotiations with Cable and Wireless Jamaica to terminate its monopoly on telephone services. I included the OUR in the said negotiations, although they were not entitled to. Consistent with the terms of the policy framework, the government enacted the Act. My Lord, at the time of the ministerial direction, which is at the heart of this appeal, in April 2002, liberalisation was still at a very early stage of development, with new entrants knocking on the door, if not all of them entering the market in Jamaica. And it was the minister's firm view, to which I will return, that promoting and fostering competition was a key policy, and I emphasise that word, a key policy driver at that time. Indeed, it is clear from a cursory examination of the history, and indeed the Act itself, to which I'll turn, that telecommunications in Jamaica in this period, and indeed still, and not only in Jamaica, is heavily policy-laden. competition and liberalisation and the accompanying encouragement of major investment was considered to be vitally important as a matter of policy, and the Minister remained heavily involved throughout the period.
Can you just tell us about the monopoly that Cable and Wireless had?
Yes.
They presumably were responsible for the fixed line system in Jamaica.
They were. As with many of the former Commonwealth or former countries associated more closely with the United Kingdom, the telecommunications industry was set up through British companies. The monopoly then became a commercial monopoly. It was an entire monopoly until the negotiations at the end of the 1990s into the 2000 period. They had a monopoly over the fixed line until 2003 or 4, after the ministerial date. My learned friends will give me the precise date. They had also had a monopoly in relation to mobile or cellular phones for, I think, of a period of about 8 years until we got to this period of liberalisation. So what they had was complete control over the fixed line network where they were a monopolist. When it came to liberalisation, they were only a monopoly in relation to the fixed line. Their own mobile network was separately categorised and was not considered to be a monopoly. Or does that assist shortly?
Yes, it is.
Yes. My Lord, there were two central statutes for consideration by your Lordships. The Office of Utilities Regulation Act 1995 and also the Telecommunications Act 2000. Into that has been inserted by the additional issue the language of the Interpretation Act, and it will be necessary when dealing with that additional issue to look also in some detail at that statute. But could I, my Lords, focus now on the two main statutes, because there appears to be some misunderstanding, some significant misunderstanding in the operative minds of the regulator as to what their powers are. And we submit that it's very important, indeed central, to understand those powers in order to explain how the ministerial direction works and why it fits neatly into the scheme of things. What we've put together in a photocopy the two main statutes, which you may find helpful. And there's another reason for that. The Office of Utilities Regulation Act 1995, as amended during this process of liberalisation, is in volume 3 of the authorities at tab 32, but I regret the last 3 pages are missing. So there's one section I wanted to take you to. Well, there should be a bound copy of that statute and the Telecommunications Act, which is in volume 5 at tab 54, if you've been working from the copies. Well, the Office of Utilities Regulation Act can be taken very briefly. This is the Act as amended in 2000, so that it married up with the emerging telecommunications legislation. Section 3 creates the body, so this was created in 1995. There is hereby established, for the purposes of this Act, a body to be known as the Office of Utilities Regulation, which shall be a body corporate. And their role was to regulate, as you'll see in paragraph 4, subject to the provisions of this Act, and those are very important words, subject to the provisions of this Act, the functions of the office shall be to A, regulate the provision of prescribed utility services by licensees or specified organisations. And your Lordships should have towards the end of the statute the first schedule which prescribes the utility services, which now includes the provision of telecommunication services, as well as public passenger transport, sewage service, electricity and water. So going back to 4, the function of the office is to regulate those prescribed utility services, and that's subject to the provisions of the Act. The same or a similar mantra appears in section 4.4. But could I pause as I go through this statute to show your lordships the language of 4.2, which gives to the office a power, if it considers necessary, to give directions to any licensee. I just underline that word because part of the submissions coming later on behalf of Cable and Wireless is that wherever you see the word direction in legislation, that takes you to the definition of regulation in the Interpretation Act, and then there is a question as to whether such a direction has legislative effect, and that would be an example of a candidate for publication in the Gazette. Or if I spent all of my time looking at the word direction in these three statutes, not only would I well be on my tolerance point, but we would find the Gazette full of directions on a daily basis. Well, 4.4, Lord, is an important provision. The office shall have power to determine, again, in accordance with the provisions of this Act, the rates or fares which may be charged in respect of the provisions of a prescribed utility service. So there's the power to set rates or fares because of the transport provision. But that's subject to the provisions of this Act.
Yes, I suppose if one looks at the schedule, there's not much scope for competition in the provision of sewerage services, or perhaps the generation and supply of electricity in an island such as Jamaica.
I'm assuming not, my lord, but you know in the United Kingdom the position has changed because of European encouragement.
Yes.
But what you have in Jamaica, indeed many of the Caribbean islands, is thriving competition in relation to bus routes, to take an example of transport.
Yes.
Anybody who's spent any time
We have had
there,
some experience of that here.
and now in relation to telecommunications. And it isn't just the end-to-end provision of telecommunications. It will then cover, as we move into this technical world, a whole series of competing services as the technology changes on a daily basis. My Lord, the important word I wanted to highlight, and why we apologise for the missing pages in the bundle of documents, is that section 4.4 is a power which has to be exercised in accordance with the provisions of this Act. And that then takes one to section 11, which was the missing page. So section 4 is subject to section 11, which was a power to fix rates, as you will see, introduced in 2000. So this was at the same time as the Telecommunications Act. Subject to subsection 3, the office may, either of its own motion or upon application made by a licensee or specified organisation, whether pursuant to subsection 1 of section 12 or not, or by any person, and interestingly here, by order published in the Gazette, prescribe the rates or fares to be charged by a licensee or specified organisation in respect of its prescribed utility services. So there one is, again, seeing a power, but it's subject to subsection 3. Subsection 3, the provisions of subsections 1 and 2 shall not apply in any case where an enabling instrument specifies the manner in which rates may be fixed by a licensee or specified organisation. And if one goes back to the definition, unsurprisingly, an enabling instrument on the first page, section 2, in relation to specified organisation, means any enactment other than this Act and any permit. So if we go back to 11.3, the provisions of subsections 1 and 2 shall not apply in any case where an enabling instrument specifies the manner in which rates may be fixed by a licensee or a specified organisation, which is to take one to the Telecommunications Act. So that's the touchstone for the setting or power to fix rates. But even if that is wrong, Lord, I highlight that this is a power and not a duty.
So you say Section 11 is inserted at the same time as the 2000 Act?
Yes. Yes. You should see on the side, my Lord,
Yeah.
reference to 14/2000.
Do we have a print of the Act as it was before that?
We don't, my Lord. If I can find one, sometimes it's a difficulty. As we have the office here, they may have a library with the old 95 Act. But I found it sometimes quite difficult to find printed copies.
But of the things we've been looking at, what came in 2000?
Well, my Lord, obviously the inclusion of telecommunications in Schedule 1,
Yes.
because that would not have been regulated when you had a monopoly provider.
I follow that.
But are they the ones marked in the margin?
But they're all as marked. It's whether or not they were complete rewrites, such as 2A, which was introduced in Section 7, was repealed, or whether they were merely changed. Well, it's not clear. But what is clear, and indeed explained by the Minister, is that he, the government, were changing the Office of Utilities Regulation Act so that the existing regulator would have powers in relation to telecommunications, but that takes you to the Telecommunications Act. Well, that's the point I'm trying to make.
Is 14 of 2000 a reference to the Telecommunications Act or some other act?
Lord, it may be to a statutory instrument, but it could be to the Act itself.
Well, at the very beginning, it says at the top, Acts, 13 of 1995, 14 of 2000.
The number, the 2000 Act itself, my Lord, is Act 1 of 2000.
So this is a different act.
So there would have been an amending Act in number 14 of 2000, which we'll try and get hold of that, my Lord, and that may answer your Lordship's question. But I don't have it to hand again. Could I put apology up for all of these omissions? Lord, that's all I wanted to show you at the moment on the Office of Utilities Regulation Act. But it's important to see, first of all, there are powers, as one would expect, but also they are linked, indeed, they move across to the Telecommunications Act. So could I now turn to that statute? Well, this is, of course, is the central statute for our consideration, and a very important statute in Jamaica, as it is still as drafted. I don't think there have been major amendments, if any amendments, since 2000. And your Lordship should have that in the immediately following pages, or the next tab. Your Lordship will see from Section 2 that this was an act which was to come into effect from the 1st of March 2000. That gives you a clue as to the date of the breaking of the monopoly held by Cable and Wireless. And there are some definitions, some of which are picked up in the aids that your Lordships have had. Could I just take you to 4 or 5 on the second page, which may be page 6 of the statute. At the top of the page, it should say existing telecommunications carrier.
I haven't got any page numbers on it.
Well, they may have been removed. Still in section 2, when you get to existing telecommunications carrier, it means Cable and Wireless Jamaica Limited. And that term comes up later as we look at reference interconnection offers.
A moment ago you told us, I thought by reference to section 2, when this act came into effect.
My Lord,
I
it's the
couldn't
very
find the
first provision. It should say the appointed day. It means the first.
Oh, I see. Means the date of commencement of this act.
I've assumed that, my Lord. I will be corrected if that's wrong. But that fits in with my understanding of the chronology.
Sorry, which was the date?
1st of March.
1st of March,
2000.
right, thank you.
So it's not a date to be appointed.
Lord, I think there are two dates. There's an appointed day when certain things are happening, and there may be another date which will be either a statutory instrument or a different statute, which brings some of these provisions in force which are not covered by that. But I'll find you the provision, Lord. But, Lord, the only reason I was using it at all was to just give you, again, a fixed mark as to when liberalisation was starting. But in the definitions, existing telecommunications carrier means cable and wireless Jamaica. Just go down to fixed network means a telecommunication network that is not a mobile network. Functions includes duties and powers. Down to interconnection means the physical or logical connection of public voice networks of different carriers.
Sorry, what does logical mean in that?
I've assumed it to be other than physical, which could be by a radio wave. There's nodding behind me, which is encouraging. There may be one or two shakings of heads as we go through this, my lord. So physical will be an interconnection switch as you go from cable and wireless to Digicel. Yes. That's the wired connection, but the system broadly is that the incoming telecommunications mobile operator wires out to a mast, a radio mast, and that then picks up and sends signals. Yes. And that's where the logical connection, I hope, is referred to. Mobile network, missing out international service and internet access. Mobile network means a telecommunications network used to provide specified services that permits a user to move continuously between places, etc., and doesn't require physical contact. So anything which is not a mobile network is the fixed network. And the fixed network was exclusively cable and wireless. Then there's a reference to license and licensees, and further down to the office. The office means the Office of Utilities Regulation, established under the Office of Utilities Regulation Act. Prescribed equipment. The reason I mention that, Lord, is this is the first time we come across the word prescribed. Unsurprisingly, it means prescribed by regulations, unless the statute itself provides for a power to make rules. Well, that's standard common law case law, but it's also part of the Interpretation Act in Jamaica. So prescribed means prescribed by regulations. And it may be worth...
Well, that wasn't so in the Office of Utilities Regulation Act. Prescribed utility service meant a utility service specified in the first schedule.
Correct, Lord. And that's the definition in the Interpretation Act, is save where otherwise appears.
Yeah.
And indeed, my lord, it may just be helpful to jump quickly to the end of this statute to see the regulation making power. Lord, it's section 71. Almost to the end, 2-3 pages from the end. But I'll show you the relevant provisions in the Interpretation Act. Section 71.1, the office may make rules subject to affirmative resolution, prescribing any matter required by this Act to be prescribed by such rules, or any matter that it considers necessary or desirable for the effective performance of its functions under this Act. And a cross note, my lord, subject to affirmative resolution, very familiar phrase, is defined in Jamaica in the Interpretation Act, section 30, subsection 2, as meaning what we know it to mean, being put before Parliament for an affirmative resolution, in other words, consideration by Parliament, by the legislature, of the language used. And I needn't show you 71.2. 72.1, the Minister may make regulations generally for giving effect to the provisions and purposes of this Act, but he doesn't have to go through the process of affirmative resolution. And there is a specific rule-making power that I'll come to later in section 46. So that's the definition. Lord, the final definition is the word telecommunications.
Is there a difference between a rule and a regulation?
Lord, I don't think so, because of Well, my Lord, I'll show you the definitions in the Interpretation Act. There may be, but it's not significant, I don't think, in these submissions. Well, the only other definition is telecommunications. It's really the kind of thing to learn for a dinner party. It means the transmission of intelligence by means of guided or unguided electromagnetic, electrochemical, or other forms of energy, including but not limited to intelligence. I thought it should stop there, but it doesn't. It then continues in the form of speech, music, or other sounds, etc. So a wide definition of telecommunications. Well, that's the definition section. So I now move to the meat of the statute. In section 3, there are objects. The objects are A, to promote and protect the interests of the public by promoting fair and open competition in the provision of specified services and telecommunications equipment, promoting access to specified services, ensuring that services are provided to persons able to meet the financial and technical obligations in relation to those services, providing for the protection of customers, and promoting the interests of customers, purchasers, and other users, including in particular persons who are disabled or the elderly, in respect of the quality and variety of the telecommunications services and equipment supplied. So that's to promote and protect the interests of the public. B, to promote universal access to telecommunications services for all persons in Jamaica. And C, and I abbreviate, C, to facilitate the achievement of the objects referred to in A and B in a manner consistent with Jamaica's international commitments in relation to the liberalisation of telecommunications. And D, a freestanding object, to promote the telecommunications industry in Jamaica by encouraging economically efficient investment in and use of infrastructure to provide specified services in Jamaica. And, my Lord, the reason I read those words out is the case against me, raised, I think, by both respondents, is that the minister misunderstood what is meant by the interest of the public, because it's specifically referred to as an object in 3A, and he doesn't refer to 3A in his reasoning or in his direction, which we say is a misunderstanding of some basic public law principles when it comes to the determination of policy. And also, it's pointed out that 3A1 refers to promoting fair and open competition, and the minister is to be criticised to the point of unlawfulness because he failed to use the full mantra of fair and open competition, but only used the word competition in the direction, whereas in his affidavit he does refer to fair and open. What's interesting is that that's the last time you will see fair and open competition in the statute. My Lord, part 2 is dealing with administration, and this then, of course, is central. The office shall regulate telecommunications in accordance with this Act. In other words, that's taking over from Section 4 of the Office of Utilities Regulation. And for that purpose, the office shall regulate specified services and facilities, receive and process applications for a licence, and make such recommendations to the minister in relation to the application, as the office considers necessary or desirable. C, promote the interest of customers while having due regard to the interests of carriers and service providers, carry out on its own initiative or at the request of any person investigations. E, make available to the public information concerning matters relating to the industry. And then F, promote competition. Now, no longer fair and open, but matters not. Promote competition amongst carriers and service providers. And G, advise the minister on such matters relating to the provision of telecommunication services as it thinks fit, or as may be requested by the minister. That provision crops up in correspondence between the minister and the office. H, determine whether a specified service is a voice service for the purposes of this Act, and then carry out such other functions as may be prescribed by or pursuant to this Act, again, reference to regulations. Then there's reasonable standards of procedural fairness, good faith, etc. Lord, over the page, my copy, section 4.3, In exercise of its functions under this Act, the office may have regard to, and those words are important because those are the words sometimes associated with guidance. In exercise of its functions under this Act, the office may have regard to, so, and the word may as well, the following matters: A, the needs of customers; B, whether the specified services are provided efficiently and in the manner designed to 1, 2 and 3, and then C, whether the specified services are likely to promote or inhibit competition, again without fair and open. Where the office has reasonable grounds for so doing, it may, for the purpose of its functions, require a licensee to furnish information or documents. 5, the office may make rules subject to affirmative resolution prescribing the system of regulatory accounts to be kept, so that's another freestanding power, but subject to affirmative resolution. And 5 and 6 are then of central importance. Where, after consultation with the Fair Trading Commission, the office determines that a manner or any aspect thereof relating to the provision of specified services is of substantial competitive significance to the provision of specified services and falls within the function of the Fair Trading Commission under the Fair Competition Act, the office shall refer the matter to the Fair Trading Commission. So a specific power, if there is a competition concern, abuse of dominant position in one aspect or part of the market, then that's the route off to the Fair Trading Commission. 6, the Minister may give to the office such directions of a general nature as to the policy to be followed by the office in the performance of its functions under this Act, as the Minister considers necessary in the public interest, and, importantly, the office shall give effect to those directions. My Lord, just on a cursory reading, of course I'll come back to this when looking at issue 1, the Minister is here empowered to determine what he considers necessary in the public interest. He is not curtailed in that exercise by 3A, the objects of the Act. In any event, 3A, B, C and D are all public interest provisions, because the whole purpose of promoting the telecommunications industry is to benefit the public. So the power is to give to the office such directions of a general nature as the policy to be followed as he considers necessary in the public interest, and the office shall give effect. So this may mean promoting competition, liberalisation or not, or some other policy choice. It may mean, indeed it's almost inevitable, because that it will impact on the performance of a function. And that's why I've begun to identify and focus on powers or discretions. So the powers or discretions that the office holds are, to use a phrase that doesn't appear in section 6 but makes sense of the provision, subject to the exercise of the ministerial power by giving directions. What the Minister is not permitted to do is give to the office a direction of a specific nature. And a specific nature that we submit would be in relation to a specific licensee or a specific rate. What he can do, by way of example, he can direct a floor, or he can direct that competition be promoted, or he can direct your powers will not be exercised in this particular area, but what he can't do is say that you will fix the rate between X and B, A and B, or some other more specific direction. Of course, I'll come back to that later. As I've just mentioned, the language is also the language of direction, in the sense that the office is obliged by statute to give effect to those directions. And heralding the submission that comes in relation to the Interpretation Act, this you will see is a direction from one body, the minister, to another body, the office. And it is either an administrative act or an executive act. It is not a legislative act. My Lord, could I pause for just for a second? We have sought to emphasise in our printed case that this provision is common throughout the Commonwealth. It's also regularly found in United Kingdom legislation as recently as the last one we looked at was the Commissioners of Revenue and Customs, the modernised version of Customs and Excise. There's a very similar provision. So it's a well-known provision, but there isn't much case law on it. There might be a bit more after this hearing, but at the moment there isn't that much on it. It's a form, as I said, used throughout the Commonwealth. And in footnote 6, what should be page 5 of our printed case, and I refer you to a document. This was the affidavit put before the Court of Appeal in Jamaica seeking permission to appeal. And your Lordship will see that the Minister referred to at least 65 other statutes or orders that relate to almost every minister, but not aware of any cases that deal in detail with this section. But more importantly, my Lord...
Sorry, not the affidavit we looked at before.
No, my Lord, this was the one to the Court of Appeal. It may or may not have found its way into the record. It probably doesn't matter, just that section. Because over the page, my Lord, in the same footnote, there should be a reference to Record Volume 3 and Record Volume 5. If I just take you very quickly to the Record Volume 5, these are the submissions made on behalf of the Minister to the Court of Appeal. The Record Volume 3 are the submissions made to the first instance judge. So it's tab 46, my Lord. It should have a heading at record page 1989 of Respondents' submissions, and there were then two respondents in a parallel appeal, the Minister and the Attorney General. Your Lordships may have picked up there were two proceedings going parallel. And at page 2000, the Solicitor General sets out, I think, some examples. Yes, in paragraph 23 of his submissions to the Court of Appeal, your Lordship will see that it isn't just post-event, this is material before the Court of Appeal. There's an almost identical provision in at least 65 other statutes or orders. They relate to almost every minister: finance, that's two examples, social security, education, agriculture, transport, legal aid, pesticides and tourism. And in paragraph 24, he gives old and new examples: the Debentures Local Act of 1925, the recent one, the Toll Roads Act, and then telecommunications, water resources, and indeed the Competition Act also has a similar provision. And, my Lord, we've added into the bundle, and I won't trouble you with it, examples from as far away as Karnataka in central to western India, I hope, and the Central Bank of Belize have very similar provisions. And if your Lordships are interested, we can provide another dozen or so examples from the British legislation over the next few years. So it's a familiar term of phrase, but very little jurisprudence.
Is there any jurisprudence?
My Lord, the one that we found recently, we haven't troubled you with because it was merely in passing, was when there was a closing of pits and there was a ministerial direction that a particular number of pits should be closed, and that was considered too specific, but it wasn't too specific to have you will close a maximum number of pits, but I'll try and find that one.
A UK.
A UK case. Try and find that. I haven't got a copy of that to hand, but in our researchers, I mean, there's a bevy of talent. We haven't found a case that does more than point out that it uses the word general, not specific. So one then has to draw some kind of line. And one of the reasons that we're here, my lord, is that Digicel, who operates in the Caribbean, is keen to know whether or not it can rely on a ministerial direction of the terms that were used here, or whether this power is confined to generalizations of an almost useless nature. But here we have usefully two specific directions when we come to them. One is you will not intervene in the mobile market. And the second one is you will promote competition. So you've got a general and a more focused direction. And we found, when I come to it, a more recent example from this same ministerial utility regulator relationship. Lord, we haven't found, in answer to the Lord's question, a specific answer, otherwise I'm sure you would have been in the bundle, even if it was firmly against it.
And we're speaking, are we absolutely identical?
But not quite identical, my Lord. The variants are, they don't always have all the words, but the ones we have been focusing on are where the word direction is used, where it's general, and where there's an obligation to follow. To contrast with guidance to which you will have regard. And that becomes really of considerable jurisprudential importance, if I might be so bold, in that the Court of Appeal in Jamaica said that this is akin to guidance based on Laker Airways. And we say fundamentally not. This is a shall give effect to, and it is normative. That also drifts into our second issue as to whether or not it is right and proper for a public body such as a regulator simply to ignore it because they have legal advice that it's wrong. And that's what happened here. And it was for Digicel to bring the proceedings, which we say is an unfortunate way to regulate an industry. Lord, so the answer to your Lordship's question is nothing precisely on point. We will find a copy of the Cole case, but as I recall it, it just says identifying 10 pits is too specific. What we say, and again I'll develop this a bit later, is that because it's referring to general nature as to a policy, it doesn't mean that it can't be identified and articulated with some precision. It doesn't mean woolly, aspirational. And by its very language, it engages with the performance of functions. So when the responsible regulator comes to a choice as to whether or not to exercise a discretion, we say, without the direction, the regulator has a choice, doesn't have to act one way or the other, therefore commits no error of law. What's happening is the minister in this example is saying, you don't exercise that discretion in this area for very good policy reasons. Well, that's the perhaps at the heart of issue one when you get to it, although it's put in very different ways by my learned friends. So, Lord, I thought I'd just pause to show your Lordships that Section 6 is not a freak or not confined to one country. It's around the Commonwealth, and as we speak, in another place not far away, another draftsman will be writing out a similar version. Well, I hope, speed through some of the other provisions. Section 7, I will just pause on because it does become important in practical terms. There is here an obligation for secrecy imposed on the office. Every person having any official duty or being employed in the administration of this Act shall regard and deal with as secret and confidential all confidential information relating to applicants' applications for license, etc. Well, I won't go into that in great detail, but it's important when we get to a bit later in the statute, which looks at the difference between an offer document, known as a reference interconnection offer, or RIO, which is publicly consulted on, and the interconnection agreement, which might be made on the basis of that offer or may be made differently, where obviously that is highly confidential commercial information, which is a different process. Could I jump on to part 3, licensing of telecommunications services? An obvious introduction, 9.1, I'll just pause there and move straight on. A person shall not own or operate a facility. A person shall not provide a specified service, when you get down to 2, without a license. Section 10 is an interesting provision because this is another direction, power given to the minister, which we say is not fundamentally different. The minister shall, by a direction in writing, or first of all, different, it's a shall, not a may. The minister shall, by a direction in writing to the office, require the office to invite applications for the grant of carrier or service provider licenses, or both, and such direction shall specify number of licenses, facilities in relation to which the licenses will be granted, and B, upon receipt of a direction, the office shall publish a notice. And that leads to a process which ends in 11 over the page, application for license, and 11.4, which again underlines the hierarchy in this statute. After taking action in accordance with subsection 2, that's deciding whether to grant, to recommend the grant of a license in respect of an application, the office shall make recommendations thereon to the minister. The office shall recommend a refusal, otherwise it recommends that it should be accepted. So a clear relationship. 12 is a provision given to the minister, I needn't trouble your lordships with. 13, again, shows the hierarchy. Upon receipt of a recommendation, the minister may then grant licenses or refer the recommendation back or refuse. Could I then turn to, there's one other example I should point out to save having to come back to it. At 14.5, before suspending or revoking a license, the minister shall direct the office to notify the licensee accordingly. And then 6 is a recommendation. But I just point up another of the several examples of the use of the word direct in this statute, which on the respondent's reasoning requires publication. Paragraph 20, I can take this at speed, 20 to 26.
Sorry, where are we going?
20, my lord. A term that you may or may not be familiar with, and that is spectrum management. My lord, spectrum management is simply this, that up until the end of the monopoly, the spectrum, that's the method or the ability to transfer electromagnetic wave frequencies, was all...
See what it is in subsection 6.
Subsection 6, my lord.
It is.
Is it?
It.
Yes, the continuous range of electromagnetic wave frequencies up to and including a frequency of 420 terahertz. But until you liberalise the market, that would be controlled by the monopoly under its licence, or the government would grant to the monopoly incumbent. But you then need to allow those who want to compete with the monopolist an opportunity to buy into spectrum. And so what they do is bid for bits of spectrum or access to spectrum by a licensing arrangement which is covered by the Spectrum Management Authority, described in paragraph 21. And as with this authority, the office, by 21(3, it shall have regard to the office, regard to the objects, provisions and purposes of the Act. And then it makes recommendations and the Minister allocates spectrum. And when it comes to the process of allocation, the bidder ends up with paying a lot of money. And when we got to 3G in the UK, you may remember from your newspapers that it was millions and many, many millions, if not near billions of pounds for access to 3G spectrum. If I can remember the figure, I think Digicel's accepted bid was 145 million.
It's a one-off payment, is it?
It's a very large payment, which gives you your key into the market, and then you recover the cost of spectrum sliced into tiny financial units in every call that's made. And you have also in 23 another example, and the last one I hope I pick out, the Minister may in writing direct. And so we come at last, my Lord, to a central part of the statute, and a part which is of importance in understanding what the Minister was trying to achieve. This is part 5, interconnection. And this is clearly central to liberalisation of the market. You can't have a market without interconnection, because otherwise, if taking my client Digicel comes into Jamaica without interconnection rights, its customers can only speak to other Digicel customers. So you need interconnection to go to other mobile operators and, of course, to the fixed line operator, and you need interconnection to get out of and into Jamaica, into the international sector. So some terms become then very important, and they're defined in section 27. Dominant public voice carrier means a public voice carrier that holds a dominant position in the telecommunication market in Jamaica within the meaning of section 19 of the Fair Competition Act. Interconnection provider means the public voice carrier who has received a request from another public voice carrier for interconnection. Well, this is explained diagrammatically in tab 50 of bundle 5 that I was showing you earlier.
Yes. One would have thought that cable and wireless were plainly the dominant public voice carrier, but I understand that is not.
You know, in relation to fixed line, Lord,
yes,
but not in relation to their mobile line.
Yes.
Lord, they were declared dominant. I'll get to the date when this. Interconnection seeker means a public voice carrier who makes a request to another public voice carrier for interconnection. Point of interconnection means the physical location for the handover of voice telecommunication services between the provider and seeker. Public voice carrier means the carrier who owns and operates a public voice network used to provide a voice service to the public. And here we get to one of the key terms, reference interconnection office. Well, that's regularly... I've created another public body. Reference interconnection offer, regularly abbreviated to RIO or RIO, means an offer document setting out matters relating to the price and terms and conditions under which a public voice carrier will permit interconnection to its public voice network. So as we go into liberalisation, it is fundamentally important that the incumbent, who holds all the cards, puts into circulation as quickly as possible a reference interconnection offer which is approved by the regulator and then can be picked up, accepted as an offer or converted into a contractual arrangement or not. 28. Subject to subsection 2, the office shall determine which public voice carriers are to be classified as dominant public voice carriers for the purposes of this Act. So that's a task given to the office. Before making a determination under subsection 1, the office shall invite submissions from members of the public and consult with the Fair Trading Commission. A dominant voice, public voice carrier may at any time apply to be declassified. And the existence or non-existence of a dominant voice carrier is referred to by the Minister in his evidence to the Court of Appeal. And then 29 is a very interesting and important section. Each carrier shall, upon request in accordance with this part, permit interconnection of its public voice network with the public voice network of any other carrier for the provision of voice services. So a statutory obligation to permit interconnection. 29.2, a public voice carrier shall provide interconnection in accordance with the following principles. Any to any connectivity shall be granted, without going through the rest of the detail. So any form of provision will connect. So if you have a mobile phone and a digital service, it will interconnect with a fixed line or with Centennial, which was the name of the another provider at the time, taking our system O2, BT, Vodafone, and the endless small groups.
I mean, Centennial, of course, aren't here, but are they actually in an identical position to you?
They at the time they were, or their name has changed, their relationship with other providers has changed, but as at the time of the decision, exactly the same. Indeed, they adopted the submissions made on behalf of Digicel in part. Indeed, they're referred to in the correspondence as one of the causes or reasons for the minister making his direction, although there's reference to an incoming competitor who was hesitant about joining the Jamaican market. And there are other end-to-end...
Who's that? Do we know who that is?
AT&T. AT&T, is Junior reminds me. There's reference to this in the affidavit of Mr. Hay, and also reference in the correspondence. So there's end-to-end connectivity, end-to-end operability, and interconnecting carriers shall be equally responsible for establishing internet connection and doing so as quickly as reasonably practical. So we can leave all that for the moment. What then becomes important are 29.3, 4 and 5, because 29.4 is one of the reasons of the Court of Appeal as to why the direction from the Minister was unlawful. 29.1, copies of all interconnection agreements shall be lodged with the office, which may object to any such agreement in the prescribed manner. So that's a fairly clear term. So there's an obligation to lodge all interconnection agreements. So this is not the RIO, this is the agreement that has now been reached in the relation to interconnection. And the office may object, but only in the prescribed manner.
And this is an agreement between who and who?
This would, in my example, would be between Cable and Wireless and Digicel, the terms on which interconnection will take place. That will be based in part on the existing RIO by the time of the interconnection agreement with which we're concerned, or may be concerned, in somewhere in about April 2001, we'd got to the RIO, which has changed its numbers. I'm sorry to bore you with this. The reference interconnection offer had gone through phases 1, 2, and 3, and some of the material refers to reference interconnection offer 4. We've now moved on beyond that to 6 and beyond. But there was in place an interconnection offer process, and during that process, Cable and Wireless and Digicel reached an agreement. And that's the interconnection agreement, sometimes referred to by desperate people as an ICA. So we have a RIO and an ICA and another of the many acronyms.
ICA?
I hope so, interconnection agreement.
Yeah.
Yes, I hope. Lord, what's important, if I could focus on this for a moment, because this is important in terms of the regulatory scheme in Jamaica. There is no prescribed manner. As far as I'm aware, there is no prescribed manner now, in 2009. This, as you can see, could cause a difficulty. And as I understand the process, my learned friends will correct me, this is my own attempt to research this from the papers before the committee, is first of all, I've said earlier that prescribed has a meaning. Could I just show you that from the Interpretation Act? It's volume 2, tab 21. Yeah, of the authorities, more than that. And as with every interpretation act, it applies to every statute unless there is a separate provision. Lord, it's section 3, familiar language. In this act and in all acts, regulations and other instruments of a public character relating to the island, now in force or hereafter to be made, the following words and expressions shall have the meanings hereby assigned to them respectively, unless there is something in the subject or context inconsistent with such construction, or unless it is therein otherwise expressly provided. Familiar stuff. Page 9, in section 2 of the act, section 3, is the word prescribed, means prescribed by the act in which the words occur, or by regulations made thereunder, and in relation to any regulations where no other authority is empowered in that behalf in the act, means prescribed by the Governor-General in Council. And I think in the same statute, whilst we're looking at it, affirmative resolution. Yes, well, section 29. There are some interesting provisions in section 29. This is provisions as to regulations, which we know from the definition includes directions. But section 30 goes on to deal with the definition for legislative purposes. And 32, the expression subject to affirmative resolution, when used in relation to any regulations, shall mean that those regulations are not to come into operation unless until affirmed by a resolution of each House of Parliament. And going back to section 3, regulations are defined broadly. Page 10 of my copy of the statute. Regulations include rules, bylaws, proclamations, orders, schemes, notifications, directions, notices and forms. So, well, that's the statutory framework in relation to prescribed manner. And I've shown your Lordship earlier, section 71, the office may make rules prescribing any matter required by this act to be prescribed by such rules, or any matter written to the next. What we do have is that draft rules or suggested rules were put out to consultation in February 2001. Well, that's when I just lost the plot at this point, and no doubt my learned friend Mr. Batts will pick it up for us. At page 303 of volume 1, well, I should explain what I'm showing, Your Lordship. This is at page 265.1. Is the determination notice on the first reference interconnection offer, if not the first, the one that was then...
which page are we on?
Sorry, my Lord, 265.1, tab 8 of volume 1 of the record. I hope I've got the same pagination as your Lordship's have got.
I don't think we have 265.1.
That's at the bottom of the page.
Yes, yes.
At the top, it's got 419.
419. It's all, I'm using throughout the record.
Yes, yes, yes.
Privy Council record, bottom, I think it's always bottom left. Just to introduce where we are, this is a determination notice in relation to a RIO made in 2001. And at page 299 internal page 34. The drafter of this document, having referred at page 298 to section 29.3, says at paragraph 13, the Act requires the prescription of conditions and process related to interconnection. Such prescriptions relate to the content of RIOs, the process of arbitrating pre-contract disputes, and the handling of objections to interconnection agreements 29.3. Annex B sets out the proposed rules relating to these matters that the Office intends to adopt, and comments are invited by March the 13th, 2001. So these were rules which would then move on to some form of affirmative resolution. And over the page at page 275...
Sorry, this is an annex to the determination notice.
That's all it is. It's an annex under a heading, the Regulatory Framework for Interconnection, Annex A, on page 297. Again, my apologies for taking you on this paper chase, but it did seem important for the long-term relationship between the regulator and the regulated to see what prescribed means. So you find in Annex A at page record 303 at 3.1 objection to interconnection agreements. So these are suggested rules which are put out for comments.
And you ran into the sand, do you? Because we haven't got the rules.
It looks as if they ran into the sand, yes. But even by looking at these draft rules, your lordships will see that it has a timetable, as one would expect. Every interconnection agreement shall be lodged with the Office within 7 days of signing. Within 12 months from the date on which the agreement was lodged, the Office may issue a decision objecting to that agreement or any part thereof. The decision shall identify the adverse effects, see below, and shall be accompanied by an explanation of the reasons for the objection. The Office may make an objection if it considers that the interconnection agreement or any part thereof has adverse effects, which shall include any term or condition that unfairly discriminates against other carriers or service providers or is otherwise unlawful in a way which has or is likely to have the effect of substantially lessening competition in the market or materially damages the interests of customers. And 3.4, where a decision has been made to object to an interconnection agreement, in whole or in part, the Office may require the parties to offer amendments. And second bullet, make a determination of such terms and conditions, in which case the agreement shall be amended accordingly. So they are contemplating a power during the process of objection to make a determination of the terms and conditions. And 3.5, before making a determination of terms and conditions, the Office should be satisfied on reasonable grounds that there is no other action which it could take to prevent that agreement from having the adverse effects identified. Where an amended agreement is lodged with the Office, it may issue a decision in writing objecting to the amended agreement using the same procedure and criteria set out above for the original agreement. So, Lord, as far as we are aware, and we're happy to be corrected on this, that was it. But what is important is even that draft set of rules, as one would expect, set a timetable. So you lodge your interconnection agreement within a certain number of days. There is a period of time in which the Office can object, otherwise the objection falls away.
I'm sorry, I'm not sure I really... I mean, I thought under 29(3) of the Telecommunications Act, you say there's the provision for the Office to object, but they can only do it in a prescribed manner. No manner is prescribed, therefore they can't do it at all.
Correct, Lord. But the reason I'm spending time on this at all is the Office thinks it has a power to do this. The Secretary of State, the Court of Appeal focuses on the next subsection that I'm coming to. So what I'm submitting is there is doubt as to whether Section 29.3 can operate at all in the absence of prescribed rules. If I've got that wrong as a matter of interpretation, and the rules I've shown you are the prescribed manner, they have a timetable which include determination. The submission being made is that 29.4 is a freestanding power to assess terms. That's why I've shown you the draft rules, because you then come to 4. The office may, either on its own initiative in assessing an interconnection agreement or in resolving the dispute between operators, make a determination of the terms and conditions of call termination, including charges. This subsection is used against the minister, and therefore against my clients, to say that his direction is in contravention of that provision. Well, two things. It's a power. It isn't a duty. It may be more of a duty when you've got a dispute being referred, but this is an ability on the part of the office, on its own initiative, when assessing an interconnection agreement, to make a determination of terms. As we have just seen, the officer's understanding in its draft rules is that the assessing an interconnection agreement is linked to 3, which is obviously right. So when an interconnection agreement is lodged, when objecting, it may itself assess that interconnection agreement and make a determination. But if there is no lodged interconnection agreement, or the period for objection has expired, the section 29.4 power dies. That's the submission, my lord, and it's important that that is determined, whether it's right or wrong. But we also point out that this is an office which has a power and doesn't have to exercise its own initiative in assessing, and therefore we say open to the minister to direct in a general rather than specific way that I am promoting competition, liberalisation at present, hands off in relation to the mobile carrier. So that's said to be the source of the power, in part, for or the objection to the ministerial direction. Lord, 5 and 6.
And your Section 6 power to give directions is in respect of how they perform their powers and duties.
My Lord, exactly our case, but we're facing an argument and indeed a finding and conclusion by the Court of Appeal that the direction can't bite so that a power is not performed, because, the argument goes, because the office has been given functions which include powers and duties, the office may have to have regard to directions, but it doesn't have to give effect to them unless it is in a positive performing way. And I'll show you a positive example. We say this is both positive and negative. It's don't intervene, 1, and 2, promote competition. But it's important, though, to understand, or indeed invite the board, the committee, so to conclude that 29.4 is not freestanding. 29.4 is linked to 29.3. Otherwise, that just leaves commercial uncertainty. You've gone through the process of lodging, there hasn't been an objection, and then years later the office says, to use a colloquialism perhaps not used in Jamaica, "Oi, you, we want to change your terms and conditions."
Is there any other power to assess the ICA?
That's the only one that we're aware of, my lord. There's another one I'm coming to under 46, but that's of a different nature. 5 and...
What is resolving a dispute between operators?
Well, you may have a dispute between... say you put in your interconnection agreement. The minister says, I'm going to object to this. The parties then say, well, I suggest we amend 23.1 in this way to have this figure or that figure or this period of time. And the other says no. That's then given to the minister, who may decide to resolve that dispute by determining terms and conditions. He may say, no, it's a matter for the EU and the market, go away.
But that's all tied in. Is that something which happens in the context of his assessing the interconnection agreement?
Well, there's two ways of reading 4. Either that is part of the process of assessment, or it's a freestanding ability to resolve a dispute between operators who haven't agreed on an interconnection agreement that may not even have been lodged. So either it's part of the process when you'd have a dispute, or I'm content to accept that it's a freestanding power, but it has to be triggered by an operator.
And at a stage before the agreement has been
Well,
found?
one would have thought so, my lord, unless it is equivalent to an arbitration process, which one would expect to see far more detail of how the arbitral process would run.
I mean, say you're an interconnection seeker, digital, and you ask who these people, CWJ, please let's connect to your fixed line or whatever it is.
And they say no.
They say no. What happens?
Oh, my lord, there is an obligation under Section 29 to interconnect. So
Under
you
29,
may then have an
under 29.2.
yeah, and 1.
Wait a minute.
29.1 says you must permit,
Yeah.
and the other one says you shall provide. So when it comes to the terms,
Yeah.
there may then be an opportunity to engage 29.4 if there's a dispute as to the terms for that interconnection, or alternatively, what I've been submitting is that may arise in the process of a reference, a lodging of the agreement with the office. So either or. my lord.
Quite. And does your ministerial direction bear on how they resolve that? No.
And so you say 4, in assessing an interconnection agreement, in assessing a proposed agreement, but not a concluded one, because you say once the agreement's concluded, there's no longer any scope for intervention. Is that it?
That's my submission, yes. And on a clear reading of the statute, it may not have been put exactly this way in the Court of Appeal, but I consider it right that your Lordship should look at this statute with some care, because it still regulates, hasn't been amended, the telecommunications market.
I mean, in 3, when it talks about all interconnection agreements, these must be agreements which they've reached.
Exactly. Yep.
So they've,
Once they've been agreed, they're lodged. And at that point, the office has a period of time in which to decide whether to object or not. And in that process, we submit, it could itself determine what should be the terms. Lord, maybe I spent too much time on it.
But I haven't quite understood this. Subsection 3, if there's no prescribed manner, do you say that's the end of subsection?
Yes.
And if there's no subscribed manner and that's the end of subsection 3, that's the end of subsection 4 as well?
Unless there's a dispute.
Is that your primary case or not?
No, my Lord, my primary case is that the ministerial direction is not unlawful because of the existence of 29.3 and 4. But it's necessary to understand 3 and 4
You
because...
accept that, I mean, 4 can be self-standing in resolving a dispute if it is not a concluded agreement.
Yes.
But if it's a concluded agreement, I mean, are you saying that the reason there's no prescribed manner for the office to look at it is part and parcel of the direction, because they've been told they're not to anyway?
Well, but
They're not to interfere with it.
Lord, it looks... Yes, yes. If there's
Is
no...
that right? I'm not sure that wins approbation behind you.
Oh, I'm sorry, my Lord, then I may have misheard. Focusing on the carpet for a moment. My Lord, if there's been a referred dispute, we're not saying that is covered or not covered by the direction, because that would not be an intervention on the part of the office. The office is being discouraged by the policy direction from itself intervening. It's saying, let the market sort itself out. If the market needs help, one-to-one, by resolving the dispute, then for
Right,
my
well,
own part.
that's what I was really suggesting. I mean, if there's a concluded agreement between the parties, well then the direction suggests that the office is to play no part.
Yeah.
Is that possibly why there has been no prescribed manner for them to deal with the thing under 29.3?
No, I don't think so, just on the chronology. Because those draft rules that I showed your Lordship in February 2001 invited comments by March the 13th, 2001. The ministerial direction is April 2002.
I see.
Again, subject to chronological corrections. And it may be that we will be shown in a few minutes the ministerial, the rules that have been passed and we've just missed them.
Sorry, Mr. Chair, it's my fault
Of course
entirely.
not.
I don't think I've picked up what call termination is.
I'm sorry, my Lord, then let me try and explain. Let me just look at the system in Jamaica for a moment. This will be ham-fisted and clumsy, but I hope I've got it right. If you want to make a call from a fixed line which is owned by Cable and Wireless to a mobile phone which is owned by Digicel, that means that your message will have to travel down a bit of Cable and Wireless kit, jump across into a bit of Digicel kit. On the regime in Jamaica, the calling party pays. That's the regime. So the receiver, the Digicel organisation, Digicel provider, says to Cable and Wireless, the retail rate that you will charge your customer for phoning my customer is $10 a minute, whatever the rate is. That then needs to be divided so that Cable and Wireless retain some of that $10 for the use of its kit, and the remainder, and a bit for collecting or bad debt, however that's agreed between the parties, and the remainder is the termination charge that goes to Digicel. Is that?
Termination is final receipt at the end.
Yes,
Of
it's the end.
Yes.
So you have the originating part of the call and the terminating call. And we're dealing at the heart of this with fixed to mobile. So you have the fixed originating call ending up in the terminating call, and who's paying what for what? Two nods.
Reassuring
When
nod.
you turn around and you find that they're like this.
Yes.
Lord, I can illustrate that, and it may be even easier if I illustrate it a bit later by showing your Lordship the technical primer. It will almost be easier. But, the technical primer at tab 50 of volume 5, which educated me, when read with some of the key phrases. But it helped just to have a quick flick at that. Tab 50, record page 2154, is a technical primer.
Hang on.
Volume 5, my Lord.
Can't find volume 5. I know it. Yeah, I got it. Yeah, I got it.
My Lord, on my copy, one part of the illustration has faded with time, purely from use and affection, I expect, my Lord. The figure that you're looking at on page 2154, figure 1, typical fixed to mobile FTM call, fixed line user uses telephone on network A to call mobile user on network B. And looking at the pictures, on the right-hand side, there should be a mobile phone, but mine has been obscured. But that's a mobile phone with a little aerial. And on the other end is an old-fashioned Bakelite post office phone. So that's the wired connection into network A, Cable and Wireless, then interconnection with an exclamation mark because it's exciting, which can be either wires, wireless, or through a third party, and then it's picked up into network B, Digicel, with a wireless connection from its mast to the user who's walking on the streets of Kingston and hears the ring and completes the connection by pressing the green picture of a telephone. And underneath, you'll see there are three charges: the setup charge, the originating charge, the transit charge, so that's picking up the call, passing it on to the point of interconnection, and the termination charge. And the effect of the determinations were to reduce, at least potentially reduce, what Digicel receives for its part of that A to B line. And over the page, Lord, I won't go into this, it may be useful at some time to do that, is figure 2, which is a typical international incoming mobile call before full liberalisation. If I could pause there, after full liberalisation, other users, including Digicel, could make its own deals with outside suppliers and could get satellite space, indeed, if they wanted to, buy their own satellite to deliver messages to the Digicel main receiver. But this is before full liberalisation, which didn't take place until 2003. Overseas user uses their network to call mobile user on network B through local gateway, fixed line network A. And again, you're following the two boxes, ignoring the network C. Well, you go from network C down network A, fixed, and you see it's picked up the satellite dish, and that's now going across to network B. There's a transit charge and a call termination fee, and it's the relationship between cable and wireless, fixed, who has the only satellite dish. So what is it paying for access to calls from overseas, and what can Digicel recover for its end, the termination end? Well, so that's 2.8, the first page is 2.6 when we come to the determinations. Well, does that help at all?
Yes, it does, and I think it's also helped by paragraph 10 on the previous page, where it's quite simple, termination, answering a call.
Yes. Well, I wish I'd thought of that. Well, if you go into paragraph 10 to the last sentence, in diagram above, which is the one on the previous page, Network A bills its customers the total of the setup, transit and termination charges. Network A, cable and wireless, then pays Network B, Digicel, its termination charge, less the transit, which is payable to Network B. So Network B must take Network A's transit into account when setting its termination or lose value, etc. But I'll try and deal with that with a simple illustration using dollars or pence. Look, going back to section 29.
If that's the power, I'm so interested in the power to assess the ICA.
Yes, ma'am.
And when that arises, or what are the various circumstances in which that can arise,
But,
if there's more than one.
on 29.3 or 29.4?
Well, I don't.
29.3 is a power to object. That's the statutory power.
But that's post-agreement.
That's post-agreement when an agreement has been lodged. So an agreement has been reached. The agreement is then lodged, and the office...
You say only if there's a prescribed manner. If there isn't a prescribed manner, then there's no problem.
That's what we say, my lord. There have been... all I need to say, looking at our own case, is that even when one looks at the draft rules, they had a beginning and an end. They were contemplating a lodging of an agreement, an ability to object during that process to assess whether or not to change the terms, and then an end. What I'm concerned about on behalf of telecommunication operators, particularly my client, is that the office, according to its reading of 29.4, has a freestanding power at any time ever to intervene in a commercial agreement without a dispute to change the terms.
i.e. assessing means reassessing, because they may have been perfectly satisfactory under the conditions in which they were agreed, approved, if they'd had their
They say they can come in years
prescribed manner, even if they'd approved it under this prescribed manner, 3 years later they can say, now we're going to reassess. Yeah.
Do I understand you to be saying, Mr. Fleming, that this power in 3 and 4 is either where the parties actually have agreed, for the office then to say, well, you may have agreed that, but we're not happy. We're not happy with it. Or else, where somebody is trying to get an interconnection in terms of 29.1, but the person who's trying to contact with says, well, yes, of course, but on terms which are completely unacceptable to him. In that situation, they can't agree,
dispute.
and then under 4, the office resolves that dispute and in effect imposes an agreement.
Yes, Lord. I'll also go one stage further, because it does say, in assessing an interconnection agreement or in resolving a dispute, I can contemplate a factual situation where in the course of a section 29.3 lodgement there has been a dispute, or even down the road there is a dispute when both parties say to the office, you resolve it.
34 deals with pre-contract disputes.
Oh yes, I'm reminded by Mr. Bax that, quite right, I've forgotten completely. Section 34 provides for pre-contract disputes. It provides separately for pre-contract disputes.
Could an agreement itself make provision that if there were a change of circumstances, the agreement, the rates would then fall to be reassessed?
Yes, it could. And
that would be a situation.
when we look at, if it's necessary, clause 23 of the agreement between Digicel and Cable and Wireless allows on service of a notice, which could be triggered by a new RIO, for a change in terms. And I think that also incorporates in the text some reference to the role of the office. But I'll look at that.
So, I mean, did this ministerial direction say they're not allowed to fix charges?
No, not at all. No. What it said is, when it comes to your intervention as a regulator, you will not cap charges for the mobile network. And it's only charges, it's only prices or caps that he's looking at. So other terms, they can continue.
I mean, there's nothing in the ministerial direction to stop the office in respect of when the parties can't agree, fixing the charge.
No, I don't think so. That's not, as far as I can see, no. Well, it may be.
So you're saying the ministerial direction was a direction that they should not do something which they couldn't do anyway?
Well, that's if I'm right on 29.3.
Yes, yes.
But I'm facing the case that I'm wrong on 29.3.
Yes.
And that there is somewhere a prescribed manner. And in that process, I'm saying, all the minister is saying, is you have a power, you have an initiative, and the minister is saying, don't use your initiative during this period of liberalisation. And
I don't myself why subsection 4 is a freestanding, because the or in resolving a dispute is separate. So the office may, either on its own initiative, in assessing an interconnection agreement, make a determination of the terms and conditions. So it's a power given to the office to assess these agreements.
Well, that would relate it to form. That would, to 3.
To 3.
No, but well,
well, it would be the prescribed manner.
Yes.
But it wouldn't mean that if there's no prescribed manner, no separate regulations, there would be no power. There's still a power, and it's pretty clear. It's to make a determination of the terms and conditions of court termination. It isn't an objection to the whole agreement. It's limited power to assess.
My Lord, we say it's linked to 3 because you otherwise wouldn't have a trigger. So it's in the process, and you can go through 4, 5, and 6 as well because they're all run together.
It's capable of standing.
My Lord, it would be an unusual provision, but yes, it would be, with respect, the wrong reading. But it is.
The whole idea of this statute is to give the office a power to assess these agreements.
No, with respect, no, my Lord.
The agreement is possible.
Yes, the focus is on the reference interconnection offer. and the role of the dominant operator. When it comes to the agreement, there is a provision to allow the agreement to be objected to, and that's 29.3. I'm linking 4 to 3, but, my Lord, my overriding submission is that even if it's freestanding, it's an exercise of initiative, and the effect of the direction is to, say, back off in relation to price caps. Well, could I just run through 5 and 6, which are clearly linked back to 4? When making a determination of an operator's call termination charge, in other words, 29.4, the office shall have regard to the principle of cost orientation. So that is, the price of charges will be linked to the cost of providing the service. So, however, that if the operator is non-dominant, then the office may also consider reciprocity and other approaches. Reciprocity means simply, as you'll see in the next one, the same price. For the purpose of subsection 5, reciprocity means basing the non-dominant carrier's call termination charges on the call termination charges of another carrier. So that's 29, 3, 4, and 5. Well, I'm sorry it's taken a little longer than I had expected. You'll see where the submission is coming from in terms of the ministerial power.
Reciprocity actually is narrower than that wording would say. It's going to be on the other carrier. Is it involved in the negotiation?
Yeah, yes. I would have thought, yes, otherwise it wouldn't be reciprocity.
That's what I was
It'd have to be the A and B.
Yes.
So if A is offering to interconnect at $10 a minute, then that's the same price for the other way around, vice versa. Well, 30, I hope that I can not quite go to the end. Without prejudice to 29, so separate from 29, dominant public voice carrier shall provide interconnection in relation to a public voice network in accordance with the following principles. So this applies only to the dominant public voice carrier, and for the period we're looking at, that only covered, if it covered anybody at all, the fixed line network of cable and wireless.
So it's not relevant because we're looking at fixed to mobile, is that right?
But 31 and 32, maybe. 31, Lord, what's not clear again to this reader is whether or not 31 is linked only to 29.4. As a piece of statutory construction, it looks as if it should be, because it's referring to a determination, but it may be a general obligation on all providers. Can I just read it through? Each term and condition in relation to the provision of interconnection services provided to each carrier shall be determined in accordance with the relevant reference interconnection office or any part thereof, and then these important words, which is in effect in relation to the provision of those services. So the in effect RIO at the time when you agree your term and conditions is the one that bites, but not a later one. Where paragraph A does not, but not to, not subsequently.
What is the relevance? I just missed what you said.
My Lord, it's telling you that when the terms and conditions are applied, you look only to the RIO, which is in effect in relation to the provisions of those services at that time.
Yes.
Where paragraph A does not apply, by agreement between the interconnection seeker and the interconnection provider. So if it's not covered by the RIO, then just by agreement, which suggests that 31 is freestanding, even though it's using the word determination, and where neither A or B applies, by the office acting as arbitrator pursuant to the arbitration rules referred to in 34.2, which is the pre-contract arbitration provision that Mr. Clark reminded me of.
What does determined mean? I don't quite follow this. Each term and condition
Lord, I
shall be that which.
yes, Lord, when I read it first, second, and third time, I was trying to tie it back to the use of the word determined in section 29.4.
Doesn't work, does it?
Doesn't
Because
work
29.4 is before the agreement is in effect, and this says in accordance with
No, my Lord, 29.4 may be after the agreement, because it's in assessing an interconnection agreement. So you already have an agreement which you are assessing.
It's not in effect, is it? Because if your argument's right, you lodge it, you've agreed it, but it can't come into effect until the office has approved it. And if the office isn't approving it, that's when it's then itself taking it upon itself to determine it.
And that then produces the near ridiculous situation that there is no agreement at all. So that's...
Well, it's inchoate.
It is. It's incomplete. Yes, it's incomplete. Well, the reason why 31, the use of the word determined, may go back simply to the agreement is because of 31B. Because that just term talks in terms of by agreement between the seeker and the provider. So that suggests it's nothing to do with the office.
Is A in a situation where this public voice carrier has just sort of standing out there an offer, a sort of open offer to anybody who cares to come along?
Exactly. That's why it's approved by the office. So it is an invitation, an offer to the world. If you want to interconnect with me, these are the terms, and they will have been approved by the regulator. And where neither A nor B applies, by the office acting as arbitrator, and that links to 34.2. 32 is dealing with dominant and other carriers. Every dominant carrier shall...
Just going back, determined here is having a different meaning from determination.
It must mean just agreed. What? Shall be agreed, my Lord, or shall be fixed? Or
this is how you discover,
yes,
if you like, what it is. Or this is how it comes, this is how it's created.
Yes. It's either... Well, A, B and C give you three processes that you can just tick off the relevant paragraph of the RIO, or you can agree it if there is no relevant RIO provision between yourselves, or if neither of those apply, then you go to the pre-contract determination dispute.
C relates back to 4, but the other two don't.
No, my Lord. C moves on to 34 itself, which is pre-contract disputes.
I see.
Does it mean decided upon?
I see, yes.
Yes, that will do.
So what is the power of the office at the offer stage and before there's an agreement?
The only power is to act as arbitrator under 34, but it also has powers into approving the RIO. So it's impacting on agreements by determining the content of the RIO.
That power is...
Lord, we're getting to that. So I missed it already.
A reference and a RIO shall be...
It's,
yes, 32 section.
I'm getting to 30. Well, for a moment I lost...
32.
Could I just go into 32 and then complete this awful process? 32. Every dominant carrier shall, so that's cable and wireless dominant fixed line, and any other carrier may lodge with the office a proposed reference interconnection offer, RIO, setting out the terms and conditions upon which other carriers may interconnect with the public voice network of that dominant or other carrier the provision of voice services. 2. Each dominant public voice carrier who is required under this part to provide interconnection in relation to voice services shall submit a RIO to the office within 90 days after the date of determination of dominance, or at least 90 days before the date of expiry, and then there's these words, and the existing telecommunications carrier, which is defined in the statute as cable and wireless, shall submit its initial RIO within 30 days after the appointed day, and we know that that's defined by the statute as the 1st of March 2000, so it has to submit its initial reference interconnection offer by the end of March, 31st of March 2000. A reference interconnection offer shall contain such particulars as may be prescribed. Well, again, I hesitate here, but I haven't yet found the rules that are prescribed, but they presumably are around. 4, a reference interconnection offer or any part thereof shall take effect upon approval by the office in the prescribed manner. And my Lord, these 32.4 is also referred to in the set of proposed rules in February 2001. That's volume 1, page 300. But again, I haven't yet found the rules. 33, where the office is required to determine the...
But those rules relate to any RIO?
Yes, yes. Well, anyone that has been lodged, because only the dominant carrier or cable and wireless are obliged to lodge. Any other provider, any other carrier may lodge.
So this would have imposed a duty on cable and wireless in relation to mobile to their fixed, is that right?
Yes. Their whole business is covered by this specific reference, subject to submissions to the contrary. Where the office is required to determine the prices at which interconnection is to be provided by a dominant carrier, it shall, in making that determination, be guided by the following principles. So 32.3 is only applying to a dominant carrier. And that means your lordships will not have to go through the exciting process, for example, in 33E, of understanding what total long-run incremental cost is. 34, my lords, pre-contract disputes, and 34.1 allows disputes to go to the office, and the office shall make rules. Again, I'm assuming somewhere there are rules. And what is interesting is 34.4, where neither party to the dispute is a dominant public voice carrier, the office may decline to act as an arbitrator in relation to the dispute. In other words, sort it out yourselves. This is a commercial arrangement. Then competitive safeguards link the office to the Fair Trading Commission. And this, again, applies to rules subject to affirmative resolution called the competitive safeguard rules, and they apply to dominant public voice carriers. And 36, again, rules subject to affirmative resolution, and, my Lord, I think we can leave that and go probably to the, yes, to 46. Well, could I pause at 42, because I've mentioned this, it is 39.6 and 42.1 are both uses by the draftsman of the words have regard and recommendation. 39.6, in determining the obligations of a universal service provider.
Sorry, what are we reading?
39.6, my lord. So the draftsman was well capable of using the words shall have regard to. And the minister shall have regard to any recommendations made by the office, so, however, that the minister shall not be bound by any such recommendations. And then 42.1, the minister may, on the recommendation, direct. So, my lord, could I leave that part of the Act and then go to consumer protection, because this is another area where the the office and the Court of Appeal suggested that the ministerial direction was unlawful. Consumer protection is covered by Part 7, deals with interpretation, quality of service, and then no discrimination under 45. And then 46. In this part, prescribed price caps means such restrictions on the price of prescribed services as are prescribed in rules made under this section. So we have 3 prescribed in that sentence, but we're looking at price caps, and that is a word used in the ministerial direction. Prescribed services mean services to which prescribed price caps apply. Price cap means a restriction whereby the weighted aggregate price calculated in the prescribed manner for prescribed services shall not be greater than the specified price. And then 2, the office shall make rules providing for the imposition, monitoring and enforcement of price caps. Now, that appears to be a free-standing power to make rules, but it may be that it is covered by section 71, which I took you to earlier, internal page 58. The office may make rules subject to affirmative resolution prescribing any matter required by this Act to be prescribed by such rules, or any matter that it considers necessary or desirable. So it does look as if 46.2 is itself subject to 71, but either way, again, as far as we are aware, there are no prescribed rules under section 46. Well, the importance of section 46 is it became an important provision for the Court of Appeal as to why the ministerial direction was bad in law, but it's an odd section upon which to criticise the minister.
Sorry, which one?
46.2. It said that this is a duty, the office shall make rules providing for the imposition, and the ministerial direction stops rules being made. Well, that's not right to begin with, but 46 is perhaps as good an example as one can get of a very broad brush power, or function given to a regulator, and in an emerging market, Lord, there is a positive need for a policy steer from a minister if he considers it necessary into the public interest. There are, as far as we are aware, no criteria at all as to what services are to be prescribed, what the caps are, what the prescribed manner is, and all of this cries out for a minister who is receiving deputations about their concern about the state of regulation and the state of the market, to give a policy steer using his power under section 6. And your Lordship will see that 46.2 refers to imposition, monitoring and enforcement. And in relation to the particular market with which the minister was concerned, he said, for the time being, until I make another direction, don't intervene. So classic territory for a ministerial direction. Well, Lord, I mentioned earlier in answer...
Where else is the phrase price caps used in Part 7?
Well, I don't think it's used anywhere else in the statute. It may come up in determination of a RIO. That may happen.
But in this part, it doesn't.
Lord, no, I don't think so, my Lord. I'll be fairly familiar with the statute, but I'm not that familiar.
It really just means that in this as far as the price cap is concerned, it just means really in this section it means that.
Yes, Lord, but it does involve a prescribed manner, and it involves prescription, setting of rules.
I suppose subsection 2 of section 46 is in this part.
Yes, no, yes, I say exactly.
Yeah.
So can we just kind of have an overview
Yes,
of the process?
Yeah.
There's an obligation to grant interconnection. A new provider says, I want to interconnect. There's then going to be negotiations as to the agreement. If agreement's not reached, then the office can step in and arbitrate the dispute.
Yes.
If it is reached, it is then lodged. And there the office will have a look at it. And it's unlikely to say the terms are insufficiently generous. But it may say you've sewn it up to the detriment of the users, and therefore I am going to object and impose my own terms, applying the criteria that have to be applied. And if the office then says that, and it's not agreeable to the parties, then the thing falls to the ground.
Yes,
because they can't be forced to enter into an agreement.
No, but where they have reached an agreement,
yes,
and it is lodged,
yes,
and there's no objection,
yes,
it remains a valid agreement.
Then you would say the only entry of the office in the public interest is going to be price capping.
Yes.
And there aren't any rules.
There aren't any rules, but also I'm saying as well that contrary to the reasoning and conclusion of the Court of Appeal, 46 in its open textured formulation is a classic candidate for ministerial policy steer if the minister so decides. So and this applies to 29.4 as well, where there's reference to its own initiatives, or indeed to 32.4 when it comes to a process of approval, if that's what's in play. So all of these provisions are engaging they're engaging decision-making processes by the office, and they are subject to, or have to be exercised so as to give effect to the ministerial direction. Would it help, I hope it does, if I just pick out one or two documents in the chronology so you can see where this all fits into the real world? Lord, I'll do this very briefly, but I've mentioned that there was a RIO that had to be submitted and imposed on telecommunications carrier Cable and Wireless under 32.2b. That was lodged, and indeed it was approved. And it's volume 1, my lord, tab 8. It's the document I touched on earlier when showing you the draft rules for comment. And it's at page 265. So, 265 is the letter which is going to Digicel. 265, we are enclosing 3 copies of the determination on the RIO submitted by Cable and Wireless. And Cable and Wireless is required to submit a revised RIO. It is anticipated that this RIO will be consistent with the determination set out in the enclosed document, and then that's the target date for approving the ensuing RIO, and that is then a lengthy document, although I won't take you through it, but this was the...
And does the determination, the expression determination notice have a statutory...
No, my lord, I think that is their use or their attempt, perfectly understandable attempt, to deal with the word approval in section 32.4. It looks as if a reference interconnection offer or any part thereof shall take effect upon approval by the office in the prescribed manner. Well, they might not be a prescribed manner, but what is happening here is there is a determination notice approving the RIO, and D1 can see that that is taken to its conclusion at page 229 in the same bundle.
This is an optional fixed to mobile, is it? RIO?
The RIO is...
Or is it a mandatory mobile to fixed, Cable and Wireless being the dominant?
This is mandatory.
Mandatory.
It was mandatory that it should be lodged because this was the particular provision, the existing telecommunications carrier had to submit its initial reference, interconnection offer, and this is it as approved. And it covers a whole series, including services as well as tariffs. All of those, my lord, that you would expect to see in interconnection. So there's not just who pays what for what, it's to ensure that your bits of kit fit the other bits of kit because of end-to-end interoperability, whatever the phrase is. Well, page 229 of the same bundle should be...
239?
229, Lord. Just completing the chronology. You will see that it was going off for further approval. This is the same letter at 229. Mr. Hay, writing to Digicel and presumably to others, notice of approval, disapproval of Rio. On the 6th of April 2001, the office issued the captioned notice indicating the provisions of the revised Rio that have received its approval. And there have been clarifications. And so if you turn the page, my lord, there is the notice of approval or disapproval. And there's reference to the statutory framework. So there's the approval offer, which is open for Digicel or another mobile carrier to pick up. And could I show you where that happens? The same tab, my lord, tab 8.
Can I just clear my mind, going back to 265?
Yes, sir.
Cable and Wireless submitted this Rio pursuant to section 32?
32.
Yeah, okay.
And what's the reference to the Rio?
The Rio
is the Rio itself in the document?
The
reference interconnection offer that has been submitted has now gone through a process of...
Is it in the bundle?
Oh, my lord.
But could I just ask, did it submit this in its capacity as a dominant carrier, in which case it was mandatory, or did it submit it optionally?
My lord, it has a freestanding obligation. Could I take you back to 32.2?
Yes.
And the word "and" after 2b, and the existing telecommunications carrier, which, if your lordship would go back to the index, definition section 2, the second page of the text of the Act, there is a definition of the existing telecommunication carrier,
Cable and wireless.
which is cable and wireless.
Yes, I see. Thank you, yes.
So where you see the words existing telecommunications carrier in section 32.2, would your lordship just write in cable and wireless?
Yes.
So cable and wireless is discharging its statutory obligation, and the office is approving, in whole or in part,
yes,
the Rio, which is then open for acceptance.
Is the Rio in the bundle?
Well, I think it is. I heard your lordship's question. We'll find out whether it is.
Okay, thank you.
Indeed, yes, it's tab. I think we check. Just a moment.
Lord, as I'm reminded by my instructing solicitor, and we're into an iteration of a Rio, and I think in the bundle there is one without the schedules. The schedules would be as...
I've found that, yeah.
But I'll try and find and identify them.
So why at page 265, a CWJ required to submit this by the... Oh, I see. I'm sorry. No, I'm getting the year wrong. Forget it.
They're now revising...
We're talking about a following year. Yes.
So 229 is the next iteration of this Rio. And what becomes important is this leads to the interconnection agreement between cable and wireless and Digicel. So what you have is the Office of Utilities Regulation writing to Digicel saying the Rio that you have been consulted on, you've been expressing your own views, is now approved sufficiently for you to act on. In fact, I think it goes through one further iteration. and it's dealt with in Mr. Seamus Lynch's affidavit, which is tab 8, who sets out how the interconnection agreement was reached. Lord, it's, you'll see on page 18 was the reference to the cost of the license, buying spectrum or buying, I got the figure wrong, there's the figure of 47.5 million US dollars, which is quite a lot, Jamaican dollars. And then, my Lord, at 4, on the 30th of March 2000, Cable and Wireless submitted a reference interconnection offer, it should be offer, not agreement, to the OUR as required by 32. This RIO was subsequently reviewed by the OUR and its consultants, and the applicant, that's Digicel, was permitted to comment. In due course, the OUR approved portions of the initial RIO and referred several issues for further discussion and consultation. Consequently, the initial RIO proceeded through several draft stages, culminating in the current stage of RIO 4, with the OUR approving portions throughout the process. On or about the 28th of August 2001, Cable and Wireless submitted a revised RIO 4. The OUR accordingly commenced the process of approval of RIO 4, etc. The process of approval is to date partially complete, and on the 7th of February 2002, the OUR issued a termination notice setting out its decisions in relation to several aspects of RIO 4. And then 6, my Lord, gives you the reference to the agreement. On or about the 18th of April 2001, the applicant and Cable and Wireless Jamaica entered into an interconnection agreement, ICA, based on Cable and Wireless's then current RIO. The process of negotiating this ICA between the applicant and Cable and Wireless was an entirely separate process from the ongoing approval by the OUR of the RIO submitted by Cable and Wireless. The ICA set out the negotiated terms and conditions of Cable and Wireless provisions of interconnection of its fixed and mobile voice networks, and also set out the retail rates which the applicant charges for fixed to mobile call termination, with the description for the determination of a landline call by a mobile network such as that operated by the applicant, and which rates Cable and Wireless is required to bill the consumer on behalf of the applicant. That's because of the calling party pays. This agreement has been in force from its execution until the present time. The OUR has never given formal or other notice of its objection to any of the terms of the ICA pursuant to 29.3. Well, it may be worth going to the end of this, as this was material before the court. In June 2001, the OUR issued a notice of proposed rule-making, which I showed you a passage of earlier, my lords, which included as Annex C thereof rules governing the OUR's objection to ICAs. Subsequent to the promulgation of this notice, on the 31st of July, the applicant responded with its comments. To the best of the applicant's knowledge, since the delivery of its response, the OUR has taken no further step to determine the rules, nor has it issued a final notice indicating the adoption of the rules. By section 71, subject to affirmative resolution, the applicant is unaware that the rules, which the notified rules, have in fact been confirmed. So, my lord, that I hope sets the scene and then leads eventually.
And all that's common ground, is it?
Lord, all that's common ground, yes. It would be unfair to say that the relationship between Digicel and Cable and Wireless is entirely harmonious at all times. Occasional cross lines. They are in dispute on a not irregular basis. Lord, that history I don't think is contentious. Lord, there is one other witness who may assist. My Lord, just for your pen, and I won't run you through it, my Lord, this affidavit runs into, at paragraph 9, the ministerial direction, and that then led to the commencement of proceedings. So I'm just dealing with how we move from interconnection to agreement, and it's dealt with by the officer's own witness, Mr. Martin Jarvis, in volume 2, tab 12, Is it? I got it wrong, Charles. Maurice, I'm sorry, Mr. Maurice Chavez.
Or the original real. That's the real tree.
Volume 2, my lord, tab 12. So I've just been passed a note. Right, yeah, my lord, this, whilst I'm on tab 12, before I take you to the text of the affidavit, I've been sent a note to tell me that at page 955, which is in this same bundle, your lordship will find, yes, Lord, this is the answer to the question from my Lord Clerk about is there a Rio? My Lord, at page 955 is a cable and wireless proposed terms of interconnection. So that would be its draft Rio.
The first one.
I think that is the first one. I was looking for the date on all of it. It looks as if that's the original 2000 one.
Thank you.
Well, can I just go to Maurice Chavez's witness affidavit? And he confirms at paragraphs 8 and 9 well, he's now responding to the affidavit of Seamus Lynch. And he confirms, as you'll see, that the interconnection agreement has been approved. Paragraph 8, my lord, on page 914, the OUR agrees that it did send a copy of its proposed rules for the resolution of pre-contract disputes and related matters to Digicel in July 2001, and that Digicel and other players in the industry commented thereon. The rules have not been promulgated to date. However, at all material times, the players in the market, in particular Digicel, were made aware and were at all material times kept advised of the methodology and timetable to be applied. At 9, the OUR says in answer to paragraph 8 of the affidavit of Mr. Seamus Lynch that the 45-day limit stated in the proposed rules is not relevant to this matter. The interconnection agreements dated the 18th of April 2001 between Digicel and Cable and Wireless are agreements entered into which conformed to the terms of Rio 3, the approved Rio, which incorporated the OUR's determination notice of February 2001, and therefore those agreements conformed with the OUR's approval. So, well, that's probably all I need to show you.
I thought that the Rio 3 wasn't approved, but turned into Rio 4.
My Lord, there are processes of approval so that those who want to interconnect don't have to wait for Rio 10. So when you get to a Rio with a number that's approved, even if not all of the terms are approved, then you have terms which have to be offered and then can be accepted and incorporated into an agreement. Well, that's, there's of course much more, but that's the highlights in terms of when the termination agreement, when the determination of the Rio was made, which was then converted into an agreement. Well, it's a long introduction to issue 1.
And so the office was happy with it at that stage.
Office was happy with it. The parties traded on the basis of it, and Digicel's commercial operations were conducted in the expectation that it would have receipts based on that agreement, with which it could develop its own market. And Digicel has been very successful in Jamaica. Part of its success means that it also has to roll out more all the time to meet demand.
So when did it begin operating Digicel?
Lord, its license was in 2001.
And that's what it paid its 47.5 million for. What did its license, its payment of 47.5 million, what did it buy for that?
It bought access to spectrum, so the ability to use the telecommunications airwaves, whatever the equivalent is. And it bought permission to be a license provider, a license holder, therefore it didn't break the law. So from the 15th of April 2001, it first became a provider of cellular mobile services, and it had to have an interconnection agreement, otherwise it would be a pointless self-talking.
And what was the date of the operative date then of the first agreement it made?
Same date of the next day.
3 days later.
Yes, 3 days later.
15th of April.
18th of April 2001. So, my Lord, it was concerned about how it saw more regulation on the horizon, and it was concerned enough to make representations to a finance minister and to others.
Was the licence for a term?
It was, I think it's, yes, 15
years. In the first
15 years.
instance,
15 years.
With a renewal for 15.
I think there are rolling renewal provisions in the licence. My Lord, and different licences have been given since then. Lord, that was what I wanted to say by framework and introduction. My Lord, a lot of the submissions have been wrapped up into that analysis, but we haven't yet got to the text of the direction and the objections to it in law. Lord, of course, I'm ready to continue until your lordships can bear no more.
No, we shall invite you to continue at 2 o'clock.
Okay.
Outstanding. Wonderful.